It is my pleasure to welcome our kickoff speaker for this morning's program. Trial lawyer Joe Krasovec of Schiff Hardin in Chicago has first chaired many cases in jury trials from the start of discovery through trial and appeal. He serves as National Product Liability Counsel for 2 large consumer product manufacturers. Joe advises that responding quickly and decisively to CPSC investigations should be an important part of your company's protocol. The CPSC imposes strict reporting requirements on companies whose consumer products allegedly malfunction or cause injury. It's a regulatory minefield, and trial lawyer Joe Krasovec has strategies and best practices for you to stay out of trouble. Please join me in extending a warm welcome to Joe.
Good morning, everybody. Welcome out of the fog of the wine tasting. So yesterday we heard a variety of presentations, great presentations dealing with managing litigation risk. We heard about closing arguments. We heard about presenting complex scientific evidence. We heard about what to do when your employees abscond with customer lists or trade secrets. We learned about how to keep a trial theme simple, all dealing with managing litigation risk. I'm going to address a different kind of risk, a risk that unless you manufacture just cars, drugs, food, or chemicals, you're likely to come under the jurisdiction of this agency. And the risk I'm talking about is a risk that presents itself even if, in the product liability context, you've made the product perfectly, that's manufactured without a defect, there's no design defect, the warnings that you've given are proper, they have the right language, they have the right information, they have the right signal words, and yet you receive report of an incident involving exactly the hazard that's addressed in the warning. And you're thinking, well, I don't have a problem here. I've got a perfectly designed product. I don't have a manufacturing defect. I've got good warnings. I've got assumption of risk defenses or misuse defenses or comparative fault or contributory negligence defenses. I'm fine. I'm out of the woods on the litigation front. Under those circumstances, there still may be an obligation to report to the Consumer Product Safety Commission, and there's still a risk that the company could be, your company could be exposed to significant fines, even possibly criminal penalties, including jail time, and the risk of having to recall the product at a significant expense to the company. So I'm going to talk today about those obligations existing under the Consumer Product Safety Act. And let's just kind of have a little review of the Consumer Product Safety Act. It was enacted in 1972, signed into law by President Nixon. Yes, that President Nixon, that long ago. Established the Consumer Product Safety Commission, and the Consumer Product Safety Commission, or CPSC, is empowered essentially to do 4 things. It can ban dangerous products. For instance, that's why we do not see lawnmowers anymore that don't have dead man features on them, dead man switches, that automatically cut the engine power when somebody releases the handle to the lawnmower. Develop safety standards for consumer products. For instance, the limits of lead or other materials that exist in certain products. Investigate potentially defective, dangerous products. And finally, conduct product recalls. And when I say conduct product recalls, in essence, the manufacturer is conducting the recall with the oversight of the CPSC, and oftentimes having essentially been forced by the CPSC to enact the recall. The current commission composition, oftentimes the commissions, all 5 of the commission seats are not full. We happen to be at a time when they are. These are all Obama appointees, and in general, the commission in the last several years has been relatively aggressive in terms of investigation and enforcement actions and in terms of standards making. All of them are lawyers, except Commissioner Morovic, who comes from a third-party testing lab called Intertech, which tests various products pursuant to CPSC standards. Most everyone on the commission is fairly liberal, except Commissioner Burkle, who often dissents from various standard-making initiatives by the Commission. The Commission resources have expanded significantly since 2007. It's grown, basically it doubled in the last 7 years. The staff has gone up by about 40%. The CPSC used to be a resource-challenged agency. It no longer is. It used to be that you could figure that if your product didn't have a big distribution channel, if you only had 100 to 500,000 units out in the field, that you didn't have to worry too much about the CPSC. That is no longer the case. They've got the engineers, they've got human factors experts, they've got the resources on the staff to basically cover any kind of product anywhere within its jurisdiction. So the notion that you can sort of fly under the radar with the CPSC is really no longer true. So let's talk about the specific reporting obligations. Here's where the Consumer Product Safety Act gets its legs, really, with respect to manufacturers. There are two reporting obligations. These are both under the CPSA, Consumer Product Safety Act. One is Section 15 or Section 15B, and the other is Section 37. 37 is a little lesser known. So we'll start with Section 15B, which is the big one. Manufacturers and sellers includes retailers who import products from overseas. So simply because you didn't make the product but you sell it in the United States, that doesn't get you out from underneath the Consumer Product Safety Act. In fact, you're the one responsible as the retailer for the distribution of the product, even though you didn't make it. And that can present certain challenges for retailers because they have to have ready access to a lot of information about the product and its testing and design that oftentimes they don't have at their fingertips. But manufacturers and sellers must report when a product fails to comply with one of their mandatory standards. For instance, there is right now a surface coating requirement for lead for children's products of 90 parts per million. If the manufacturer receives notice through testing or other means that the product contains greater than 90 parts per million of lead on the product, they have an obligation to notify the CPSC of that under Section 15B. The other two, and these are the more subjective reporting requirements, the product, if it contains a defect which could create a substantial product hazard. You notice how somewhat amorphous that definition is. And often it's left up to the manufacturer to make a decision as to whether there's a substantial product hazard. Or that the product creates an unreasonable risk of injury or of serious injury or death. And that's the situation I was talking about at the beginning when you have a product that is not defective by any objective measure. Yet, if there are injuries that occur with respect to the use of the product, and those injuries occur over and over again, there may be a reporting obligation, even though, in essence, you have no traditional civil product liability risk. So what has to be in a Section 15B report? And this gets very important because this is where the civil penalties attach. The nuts and bolts are you have to identify the product, you have to describe it, identify who made it, talk about the nature or the extent of the possible defect or the failure to comply with the standard or the risk, and the nature of the injury posed by the risk. This report technically must be made within 24 hours of when you've discovered or you have reason to believe that you've got a reporting obligation. That is a very stringent time frame. Now, oftentimes the Commission will look at subjective factors about when actually you made your report, but making that report in a timely fashion is critical. So the best practice with respect to the timing of the report oftentimes is to call the Commission staff. And there's actually a way online to make a preliminary or a short form Section 15B report that will stop the clock ticking in terms of what the Commission will look at for whether or not you made a timely report. The other things that need to be in the report are what's your distribution chain, who sells the product, how many are out there, and what's your incident history. So the reporting best practices, if you're going to make this report quickly, you need to have at your fingertips or close at hand accurate information about your supply chain. If you're importing it from overseas, Who are you importing it from? What's their testing data? What information do they have about the product design? Because you're going to have to provide that. You're going to need ready access to the specifications, drawing, and testing data. You want to collect, retain, and track customer complaint and incident data, because that's essentially what the CPSC is going to look at in terms of what you knew and when. And so, did you wait too long to report the hazard? And the way the commission looks at it is, could there have been other incidents that would have been prevented had you made an earlier report and a corrective action taken sooner? Finally, you should investigate any incidents that are serious and retrieve the product alleged to have failed so that you can actually make a case to the commission that, in fact, the product should not be recalled. When to report? What's the rule of thumb? It is very subjective, but in general, what the commission looks at are two factors: frequency of the injury and severity. So you could have, for instance, one incident involving a death or a very serious injury. That would trigger a reporting obligation. By the same token, you could have a laceration or contusion, but you have 400 of those. That would trigger a reporting obligation. So in general, the more severe the accident or the more frequent the accident, that triggers a reporting obligation. I told you about, that's the Section 15B report, and it's important to make that report in as timely a basis as possible. The other type of report is lesser known. It's called a Section 37 report. That report requires you to inform the commission if, with respect to a particular model of product, you have settled or you have had judgment entered against you in 3 or more lawsuits or claims in a given 2-year period. And the 2-year periods are defined in the regulation. The last 2-year period just started on January 1, 2015. So we're now into this. The lawsuits and the settlements have to be within that 2-year period. Sometimes this is a reporting obligation that's overlooked. It carries the same potential penalties. Section 37 report requires you to identify the manufacturer and model. Again, the nature of the injury. Whether the case went to final judgment or was settled, you don't have to give the settlement amounts, but if there's a final judgment, you have to inform the commission of the case name and where the case was pending. So the civil and criminal penalties. Civil penalties, which is the more common tool that the commission uses, this was increased as a result of the Consumer Product Safety Improvement Act of 2008. It provides for $100,000 for each separate offense, up to a maximum of $15 million for each product and each risk. This is where the commission will come after a manufacturer or a retailer if they fail to timely report. There are criminal penalties, maximum imprisonment up to 5 years. The only time that we've seen this is when an importer imports a product that they know contains, knowingly importing a product that contains a banned hazardous substance or a substance in excess of the existing limits. So it's really the civil penalties that we're most concerned about. And these penalties can be significant. So going through a typical scenario, if the commission determines, after looking at the Section 15B report and looking at the incident data and the severity of those incidents, that there was not a timely report made to the commission can issue a fine. These are some recent fines. No fine is less than 6 figures, and most of the fines range from $2 to about $4 million recently. So it's real money. It's real risk that you're facing, again, even if there really is no civil litigation risk. And you can see these are anything from children's drawstrings on children's wear, defective ladders, violation of the lead paint ban, violation of lead content in the regulation. Meyer was caught distributing a recalled product. They were fined $2 million for that. And when I say fine, in essence, these are all settlements because the commission does have the authority to go through an administrative law process and ultimately to the courts to require a company to pay a fine. In reality, most companies settle this because both the exposure of litigation or the PR of litigation and the expense and cost of it are often too much to fight, and these settlements are entered in roughly these amounts. Last thing I want to talk about, and this to talk a little bit about how you can act proactively. So in addition to keeping all of your incident data, tracking that, looking for trends so that you can make an affirmative report to the commission when you see a trend developing with respect to a hazard in a product. The other thing, and this was part of the Consumer Product Safety Improvement Act, was the act required the commission to set up a publicly available searchable database. And what that ultimately came to be known as is saferproducts.gov. And this is a place where consumers can log on and they can post an experience that they've had with a product, an issue that they've had, an injury. They can list the manufacturer's name, what happened, the date that it happened, and any contact they've had with the manufacturer. They post that on the CPSC website. It doesn't become public until after a 10-day notice period in which the CPSC gives the manufacturer notice of the information received from the consumer. Now, as a practical matter, the commission will send the manufacturer a letter that oftentimes doesn't get to them until well after that 10-day period. Now, in my experience, the commission isn't that diligent, or the staff isn't that diligent of getting the public post up right at 10 days, but it's usually within less than a month. And oftentimes, the manufacturer doesn't have time to react to what the posting is. What can the manufacturer do in reaction? Well, number one, you can verify whether it's even your product. And if you inform the commission that the product that's at issue that's been posted on the website, you don't make it, or there's something unauthentic or problematic about the post, not that you just disagree with it, but that there's something substantively wrong with what the consumer is saying, the commission doesn't have the obligation. It can withhold the post from putting it up on the public website. The manufacturer, even if it does go up on the public website, is allowed to give a response. So what can you do about this timing issue? And this is actually just a screenshot of the saferproducts.gov, but you can see that up in the upper right-hand corner, there's a little blue box that says Business Sign-In. And as a manufacturer or a retailer, you can register on the business portal page of the saferproducts.gov. That's that large blue field in the middle where it says Register Today. You click on that, you give your information, you give an email contact, a contact person within your organization. Then when the consumer makes a post to the commission about an incident, you immediately get that email. And so you're well within the 10-day time frame to respond and say, for instance, that's not our product, we didn't make that, or there's something else suspicious about the posting. I encourage manufacturers to register with the CPSC. They like to know, they like it. It creates a rapport with the CPSC. It helps the CPSC do its job, and it helps the manufacturer do its job, so that when it's seeing data come in, it's getting it on a faster basis, so that it can make a faster decision in terms of reporting. So ultimately, either the CPSC may come to you and say, we think we've got, based upon the data that we're seeing that consumers are reporting, that we've got a reporting issue, or you've got a reporting issue and you file a report. You can contest whether or not there's really a product defect or a hazard, or you come into that data, you figure that data out yourself from sources like this or what you're getting from your consumer complaints. You can still make the report to the CPSC and say, here's what we've got, but we don't think it's a substantial product hazard, but we want to report it to you so that you can shield yourself from the fines. The trick here is to watch the data, record it as it's coming in, look at trends, and be in a position to act and make a report to the CPSC in order to avoid exposure to fines. Thank you very much.